The legal system in the United States is what is known as a dual court system. This means that there are multiple systems of courts that can be involved in resolving any legal dispute. As a result of the dual court system, a variety of factors, details, and other considerations must be looked at when attempting to resolve a legal issue. Understanding this system, as well as how the details play a role in the process, is essential for American citizens because it allows us to both have our rights protected as well as get the proper resolutions to our legal issues. What is a dual court system? In short, a dual court system is simply a system that uses multiple levels of courts to resolve its legal issues. As you can see from the chart, the United States has two major parts to its court system. The first are the blue courts, which are known as the state courts. These include local courts or magistrates that handle minor issues such as parking tickets or speeding violations or truancy from school. And then there is another level of courts known as county or state courts. These courts tend to handle the more serious offenses within a state and are set up to handle legal issues throughout the different regions of a state. Once a case is heard in its original court, there is also the opportunity to have that case and its decision reviewed in an appeals court. These courts review the decisions from a lower court and decide if the original decision was handled correctly. If not, these courts have the ability to overturn the decision and issue a variety of rulings that will be looked at later on in this unit. The last component of the state court system is a state Supreme Court. This is the highest court in a state, and it has the final say on any issue of state law or state constitutional activity. These courts have the ability to hear appeals and overrule the decisions of any court beneath them in the state court system. The other major component to the U.S. court system are the federal courts, which are depicted by the two yellow courts in the chart. The federal court system is similar to the state court system, but has one fewer step because the U.S. Supreme Court is actually part of the federal court system. Federal court system begins at the district level, where most cases are heard. Then cases can progress to the appeals court level for review, and finally to the Supreme Court of the United States if the Supreme Court chooses to hear the case. The Supreme Court is ultimately the highest or most powerful court in the dual court system because it has the ability to hear, review, and overturn any legal matter that began in the federal court system. It also has the authority to hear, review, and overturn many of the legal decisions that start in the state court system as well. What is the difference between the federal court system and the state court system? The major differences between the federal court system and the state court systems throughout the United States can be observed in how the court systems are structured and how they handle their day-to-day operation. The number of courts, the type of courts, as well as the number of chances for appeal can all be different and usually are different between the federal court system and the different court systems throughout the 50 states. Another option that can be different is whether you have your legal issue heard in a jury trial, where the decision of guilt or innocence or liability in the case of a civil trial is determined by a jury, or whether you hear your case and have it tried simply by a judge in a bench trial. As you can see from the chart on the right, in looking at the first two boxes, there are a variety of different courts that exist within the United States. In the case of the federal court system, these are all established by Congress based on their authority in Article 3 of the Constitution. In the case of state courts, these court systems are established and regulated either by the state constitution or by the Congress of the state, if it is given the authority to regulate the court system in the state constitution. The second major factor where we see a difference between the federal court system and the state court system involves the concept of jurisdiction, which we will be looking at in more detail later on this week. Jurisdiction is crucial in determining what cases or issues a court is eligible or responsible for hearing, and it also has an impact on how significant the court's decision is. If a court is an appeals court or a Supreme Court, it has a much more significant level of reach and impact in its decisions than a lower level court, such as a district court or state magistrate. As you can see in the bottom two boxes, the two systems have a different process and different number of options for having a case appealed and reviewed if one of the parties believes the case has not been resolved properly. Please take a moment to review this chart before moving on with the video lecture. Why do we have multiple court systems? The United States legal system is impacted by three basic factors. The first is the idea of federalism, which we've reviewed earlier in the year. As a result of the division of power between the state and federal governments, we have two sets of laws that we live under in the United States: federal laws and state laws. The fact that we have two different sets of laws requires us to have two different sets of courts in order to handle the legal disputes that come with these laws. Secondly, we have a dual court system to organize and effectively manage all of the legal issues that occur throughout the United States. This system is similar to the bureaucracy in the executive branch, where there are a variety of courts, and each court is given a specific set of responsibilities or legal issues that it has to deal with. The judges in these courts often specialize in particular areas or categories of law, making them experts in those legal fields and the proper people to make the decisions on those legal issues. This system also helps us resolve areas in particular regions or parts of a state or parts of the country, so that we do not have to travel long distances and make the legal process more difficult. And it allows us to have the opportunity to review and correct legal decisions that may have been done incorrectly at a lower level of the court system. As you can see from the chart, each court system has different responsibilities. Most of the cases in the United States are handled by the state court system. Since most criminal cases are a matter of state law, they go to the state court system. Since most contract cases or tort cases, such as personal injury or property damage, involve parties within a state, they are handled by the state court system. Since these are state laws and state issues, state courts are usually the final decision makers in these instances. They have the last say in any legal issue. However, if the case involves a matter of constitutional law or the rights of citizens, as outlined in the Constitution and the Bill of Rights, then the state's decision may be appealed to the U.S. Supreme Court, since it is at the top of the dual court system. Federal court system, on the other hand, is much more specified in the number of cases and types of cases it hears. The federal court system deals with all cases that involve the constitutionality of a law. If a state passed a law prohibiting the freedom of speech or freedom of religion, citizens would be able to sue their state in federal court because the Constitution is the document that governs the federal government and protects the rights of citizens all throughout the country. Any instance where we have a federal power or a federal law that overrides a state law, that case would have to go to the federal court system. And then any cases involving federal government employees, such as ambassadors, diplomats, or other figures within the U.S. government, such as FBI agents, postal employees, or other bureaucrats, those cases would also be directed to the federal court system instead of the state court system. Lastly, any dispute between multiple states is heard in the federal court system to ensure impartiality and a fair trial for all involved. Ultimately, these decisions are influenced by the concept of jurisdiction. Who is involved in a case? What laws or issues are being reviewed in the case? Where the case occurred? And any other key details of the case are used to determine which system and which court within that system ultimately decides and has responsibility for resolving a legal issue. While the dual court system does an effective job of organizing and carrying out the legal work of the judicial branch of American government, there are a few negatives that happen as a result. The first negative is confusion. Since there are many courts and a variety of ways a case can work its way through the court system, citizens may not know or understand where their case fits into the system and how to properly resolve their legal issue. There is also the issue of jurisdictional conflict within the dual court system. Since we have two systems of courts, it can be difficult to determine which one actually has the authority to hear a case. In instances where we have parties from multiple states or a state and federal law being broken, we have a jurisdictional conflict. There are other instances where we have what is known as concurrent jurisdiction, where cases can involve legal issues from both the state and federal court system, and we have to ultimately choose how the case will start and which process, which system will be responsible for resolving the issues. This will be looked at in more detail as we look at the different types of jurisdiction and the different types of cases later on this week. The third negative of the dual court system is inconsistent justice. Since we have 50 states with 50 different court systems, the standards, punishments, and outcomes of similar legal issues can be different in different states. Penalties for violating traffic laws, for instance, can be different in different states. The rules and regulations about things such as abortion can be different from state to state. And this ultimately results in inconsistent legal decisions where citizens in one state may feel their rights have not been properly respected or have been inappropriately infringed upon because their decision was different from another state. This is why we ultimately have the appeals process and connect the state court system to the federal court system by allowing the U.S. Supreme Court to review what has gone on in the state. Lastly, as a result of the different levels and procedures of the dual court system, the legal process can be very time-consuming. Cases that begin in a state trial court or local magistrate can often take years to work their way through the state court system and ultimately to reach the Supreme Court if there are significant issues with the decisions in the state court system. This can make getting your legal issue resolved properly and effectively difficult for citizens who may not have the time or financial resources to be involved in a lengthy court process. Ultimately, the dual court system exists to effectively manage all of the legal issues in the United States. Through its different levels of courts and different court systems, And with the variety of factors that we will be looking at throughout this unit, it does an effective job of handling the legal workload of the judicial branches of both the United States government and the governments of the 50 states.